If you or someone you love is planning a trip to the United States in 2026, then what we are about to discuss today may be one of the most important immigration updates you hear all year. Because right now, thousands of travelers around the world are walking into U.S. visa interviews completely unaware that they could be asked to pay a massive refundable bond of up to $15,000 before their tourist visa is issued. Imagine preparing for months, collecting documents, paying visa fees, booking appointments, organizing travel plans, only to suddenly hear a consular officer say that before your visa can be approved, you must first post a financial guarantee worth thousands of dollars. That is exactly what is now happening under the United States Visa Bond Pilot Program, and if your country is one of the 50 currently affected nations, this policy applies directly to you. Over the last several years, visa overstays have become one of the most debated issues in American immigration policy. Many people enter the United States legally on visitor visas, but remain beyond the authorized period granted to them at the port of entry. According to Department of Homeland Security data, tens of thousands of individuals from various countries overstayed their visas during fiscal year 2024. The U.S. government argues that tracking and removing overstays after they happen is expensive and difficult. So instead of focusing only on enforcement after the fact, the government introduced a financial deterrent designed to encourage visitors to leave the United States on time. That deterrent is the Visa Bond Pilot Program. The program officially launched on August 20, 2025. After the Department of State published a temporary final rule under authority granted by the Immigration and Nationality Act. Under this policy, consular officers now have the authority to require certain B1 and B2 visa applicants to post a refundable bond ranging from $5,000 to $15,000 before their visa is issued. Think of it like a security deposit. The logic behind the policy is simple. If travelers have a significant amount of money tied to compliance with their visa terms, they may be less likely to overstay in the United States. But here is where confusion begins. Many people believe that everyone from the listed countries must automatically pay a bond. That is not true. The decision is made individually during the visa interview. A consular officer reviews the application, examines the applicant's travel history, financial background, ties to the home country, employment situation, and purpose of travel. If the officer believes the applicant qualifies for the visa but presents a higher overstay risk, the officer may then require a bond before issuing the visa. This means two applicants from the same country can receive completely different outcomes depending on their individual circumstances. The expansion of this program in 2026 dramatically increased global attention. On March 18, 2026, the Department of State announced that 12 additional countries were being added to the program effective April 2, 2026. Those countries included Cambodia, Ethiopia, Georgia, Grenada, Lesotho, Mauritius, Mongolia, Mozambique, Nicaragua, Papua New Guinea, Seychelles, and Tunisia. These additions brought the total number of affected nations to 50. Countries already in the program include Nigeria, Bangladesh, Nepal, Cuba, Venezuela, Malawi, Zambia, and many others spread across Africa, Asia, Latin America, and the Caribbean. For millions of people, this policy suddenly changed the entire financial reality of visiting the United States. Now let us talk about what actually happens during the visa interview, because this is the part people misunderstand most. Imagine arriving at the U.S. Embassy after months of preparation. You hand over your documents. The officer asks questions about your trip, your family, your job, your income, your previous travel history, and your plans in the United States. If the officer decides your case qualifies for approval but requires a bond, they will instruct you to complete Form I-352, known as the Immigration Bond Form. You do not hand over money at the embassy window. You do not pay cash to embassy staff. Instead, you receive instructions directing you to pay electronically through the official U.S. Treasury payment portal known as pay.gov. This detail matters enormously because scammers are already targeting confused travelers online. Some fake agents claim they can process visa bonds through unofficial systems or guarantee approvals in exchange for money. The State Department has made it very clear that the only authorized payment platform is pay.gov. If you pay anyone else, your money may disappear permanently. One of the biggest misconceptions online is that paying the bond guarantees visa approval. It does not. The bond is simply an additional condition that may be attached to visa issuance. A visa can still be denied if the applicant fails to meet eligibility requirements under immigration law. This is why honesty, preparation, and documentation remain absolutely critical throughout the process. Another major change involves the visa validity itself. Immigration law firms analyzing the pilot program have noted that visas issued under this system are often far more restrictive than traditional tourist visas. Many bonded visas are valid for only 3 months, allow a single entry, and limit the visitor to a maximum authorized stay of 30 days. Compare that to the standard tourist visa many travelers are familiar with, which can sometimes remain valid for 10 years with multiple entries and stays lasting up to 6 months. This means travelers must plan carefully and strictly follow the conditions attached to the visa. There is also an important rule regarding ports of entry and departure. Travelers using bonded visas are generally required to enter and leave the United States through designated commercial airports. Why? Because Customs and Border Protection must electronically verify your departure in order for your bond refund to be processed correctly. If someone exits through a land border crossing into Canada or Mexico or uses a non-designated exit point, the departure may not be properly recorded. That can trigger investigations, delays, and even bond forfeiture. Now let us discuss the question everybody cares about most. Do you actually get your money back? The answer is yes, but only if you follow every rule. According to official State Department guidance, the bond is refundable if the traveler leaves the United States before the authorized stay expires, if the traveler never actually uses the visa, or if the traveler is denied entry at the port of entry. In those situations, the government cancels the bond and the funds are returned. Usually within 6 to 8 weeks, according to current legal analysis and immigration reporting. But if the traveler overstays, violates visa conditions, or attempts to change immigration status while inside the United States, the situation becomes much more serious. The Department of Homeland Security may refer the case to U.S. Citizenship and Immigration Services for what is called a breach determination. If USCIS determines the traveler violated the terms of the bond, the money may be permanently forfeited. That means the entire $5,000, $10,000, or $15,000 could be lost. Think about how devastating that could be for an ordinary family. In many countries affected by this program, $15,000 represents years of savings. Critics argue that the policy unfairly targets lower-income travelers from developing nations. Supporters argue that it is necessary to reduce overstays and strengthen immigration compliance. Regardless of where people stand politically, the reality is that this program is now active and affecting real people every single day. Imagine a father traveling from Bangladesh to attend his daughter's graduation in New York. He receives a $10,000 bond requirement, pays it through pay.gov, enters the United States legally, enjoys time with family, and returns home before his authorized stay expires. Weeks later, the full bond is refunded successfully. That is the ideal scenario. But now imagine another traveler who misses a return flight, stays beyond the permitted period, and leaves late. Suddenly, the entire bond is at risk, and future visa applications become significantly more difficult. This is why preparation matters more than ever before. If your country is on the affected list, start planning financially before you even apply for the visa. Gather documents proving strong ties to your home country, including employment letters, bank statements, business ownership records, property documents, marriage certificates, and evidence of family obligations. Consular officers are looking for proof that you have compelling reasons to return home after your visit. And if your circumstances change after arriving in the United States, do not make immigration decisions without professional legal advice. Something as simple as overstaying unintentionally or misunderstanding visa conditions can create long-term immigration consequences that follow you for years. As of May 2026, the Visa Bond Pilot Program remains a temporary initiative operating through August 2026 while the government evaluates results and collects compliance data. Officials have reported high compliance rates among bonded travelers, but policy experts believe additional countries may still be added in the future. That means staying informed is absolutely essential. At the end of the day, this issue is about far more than immigration paperwork. It is about families trying to reunite, grandparents attending weddings, parents celebrating graduations, business travelers pursuing opportunities, and ordinary people trying to visit loved ones legally and responsibly. Nobody wants to arrive at a visa interview blindsided by a policy they never knew existed. Knowledge is protection, and that is exactly why conversations like this matter. Before making any travel decisions, always verify the latest information directly through official government sources including travel, state.gov, DHS.gov, and CBP.gov. Immigration policies can change rapidly, sometimes without much warning. And if your situation involves previous overstays, visa denials, immigration complications, or questions about bond compliance, speak with a qualified U.S. immigration attorney who can guide you based on your specific circumstances. If this video helped you understand the new U.S. visa bond rules in 2026, share it with someone who may need this information right now. Families around the world are trying to navigate an increasingly complicated immigration system, and accurate information can make a huge difference. Stay informed, stay prepared, and most importantly, take care of yourselves and each other.